Hello, Chris McArdle is my name from McArdle Legal in Sydney. I want to give a presentation today about statutory provisions called privative clauses, whereby appeals are prohibited, and secondly, the question of apprehension of bias as a issue of law, not fact, and whether or not it has any effect on a privative clause. I commence with the New South Wales Industrial Relations Act 1996, section 179. It says this is a reference to the powers of the New South Wales Industrial Relations Commission. 1. Finality of decisions. A decision of the Commission, however constituted, is final and may not be appealed against, reviewed, quashed or called into question by any court or tribunal. In other words, you can't take them to court and get a writ of certiorari, etc. Proceedings of the Commission, however constituted, may not be prevented from being brought, prevented from being continued, terminated or called into question by any court or tribunal. The section extends to proceedings brought in a court or tribunal in respect of a decision or proceeding of the Commission on an issue of fact or law. This section extends to proceedings brought in a court or tribunal in respect of a purported decision of the Commission on an issue of the jurisdiction of the Commission, but does not extend to such purported decision of the Commission in court session. This section extends to proceedings brought in a court or tribunal by any relief or remedy, whether by order in the nature of prohibition, certiorari or mandamus, or by injunction or declaration or otherwise. In other words, equitable remedies are unavailable against the New South Wales Industrial Relations Commission. Somewhat academic now, the jurisdiction of the Industrial Relations Commission of New South Wales has been greatly reduced by constitutional cession, whereby the powers, the industrial relations powers of New South Wales were ceded to the Commonwealth, which gave rise to the Fair Work Act of 2009. But there was a significant provision for quite a few years, particularly in the area of occupational health and safety and in the unfair contracts jurisdiction. There was a case called Husman and Walker of the 1990s where they went to the New South Wales Court of Appeal, and the New South Wales Court of Appeal found that the actions of the full bench of the Industrial Relations Commission of New South Wales were wrong. But the wording of the New South Wales Court of Appeal was, but the Commission has jurisdiction to be wrong. So in other words, a mistaken decision could not be overturned. A question of fact could not be overturned. In my view, and I think it's a view that is borne out by fact, is that this is, in the long term, a most unfavourable provision for any tribunal to have. That immunity, if you like, of the New South Wales Industrial Relations Commission came to a blinding halt, and it had significant social and legislative repercussions earlier this century. That is, that if you have no oversight, you go about doing things in your own particular way, so that under the occupational health and safety jurisdiction, it became almost impossible for an employer to be acquitted. And people only got acquitted on technical grounds. For instance, there was a dreadful case of a collapse of a lift in the eastern suburbs of Sydney, where the proprietors of the building concerned, as being strata managers, being a strata plan, an owners corporation, were prosecuted under the Occupational Health and Safety Act because someone had been seriously injured by the collapse of a lift. They got off, to put it in that expression, because it was found not to be a place of work. It was exclusively a residence, and so on. They were the only way people got acquitted. We did have one case where a person had a crane, had the crane designed in a particular way, situated in a particular location, so that if anything fell off this crane, it would cause no injury to anybody. There was a void under it. Unbeknown to the proprietor of the crane, a person had rigged a load on it that had been improperly rigged up, and the load fell off after it had gone up about 5 floors, but landed in the void that had been designed so that no one was injured. But a piece of scaffolding was bent on the way down. Well, it was found that there was, quite illogically, you'd say, that there was nothing preventing that person doing something, whatever that would have been, to have prevented the accident taking place at all. It was an accident outside the control of the person, but they were still convicted and fined $30,000. That's one isolated example of dozens and dozens of such cases. It all culminated in the case of Kirk versus WorkCover. Now, Kirk owned a farm. He was the owner of the farm. He wasn't the operator of the farm. He was not a skilled farmer. He retained a farm manager to occupy a dwelling on the house, on the farm, and to operate the farm. Kirk himself lived in the city of Sydney, over 100 kilometres from the farm. The farm manager, when taking some equipment on a quad bike, an instrument of transportation I strongly advise all persons never to get on a quad bike, took an unexplained shortcut. The quad bike tipped over, landed on him and killed him. The New South Wales Industrial Relations Commission found to the effect that there was nothing practicably preventing Kirk conducting a safety briefing with this person every morning. And there was nothing practically preventing Kirk this person from riding a quad bike or taking an unauthorised shortcut, and so on. That has something to do with the decision of the late and outstanding Justice Fisher of the 1990s, who, when ruling on a case where a tradesman had removed a safety tag from a switch room in a power station, had entered it and started working on it and had killed himself with 11,000 volts. The Industrial Relations Commission there found that the employer had a right to rely on the skill of others, and if not, who watches those who watch? If sealing a door was not sufficient, but you'd have to have a guard on the door to stop people coming in, who would then guard the guard in case the guard wasn't guarding properly? And then who would guard that person? It became ridiculous. An employer had a right to practicably rely on other people. Well, that was not the case in this Kirk versus WorkCover. That's how the jurisprudence had evolved, if you can call it jurisprudence, whereby Kirk was found to have been liable and fined thousands of dollars because he wasn't present 100 kilometres away every single morning to give a briefing to someone who then did something inexplicable leading to his own demise. Kirk appealed to the New South Wales Court of Appeal. The New South Wales Court of Appeal found that this privative clause prevented them from intervening. It was then referred back, and it was then ruled on again that Kirk was liable and fined several $100,000. Kirk appealed to the High Court, which found that privative clauses only apply if the tribunal concerned is acting within its jurisdiction. And in that case, it acted outside the jurisdiction. One of the extraordinary things in Kirk was that it's a court of criminal jurisdiction, the Occupational Health and Safety jurisdiction of the Industrial Relations Commission, and therefore it was bound by the rules of evidence. And one of the rules of evidence is that a person on a criminal charge, which Kirk was, cannot be obliged to give evidence against himself. And the only evidence for the prosecution in that matter was the inspector of WorkCover and Kirk himself, called by the prosecution. That evidence should not have been admitted. It's a lengthy judgment. I personally recommend the judgment of Dyson Hayden in that matter, where it points out that specialist tribunals only have any protection under any statutory instruments such as the privative clause if they do not stray outside their area of jurisdiction, and if they do not stray outside the application of the rules that apply to them. And in that context, we can look at the Migration Act 1958. It says a couple of things. First off, same thing. Migration Act 1958, Section 474, Decisions under Act are final. By the way, before I move off Kirk, the outcome of that is that it became practically impossible for prosecutions to be brought by work cover. And when I say practically, I don't know what was going through the minds of anyone, but there was a hiatus in prosecutions, so that there became a large build-up. Then, without very much opposition at all concerned welcomed the abolition of the work health and safety jurisdiction before the Industrial Relations Commission of New South Wales. It's now a district court jurisdiction. It's handled by judges who do other matters besides occupational health and safety and employment. It's no longer a specialist tribunal, and the results are what you'd say expectation results. If you've done right, you can expect to get off. If you've done wrong, you can expect to get convicted and fined. The idea that you were just going to lose no matter what happened. For example, in the case of Gretley Colliery, which is a famous case where 4 miners were killed. It came before the Industrial Relations Commission of New South Wales. When I say it came before it, the employer was not prosecuted. The employer of the labour was a labour hire company owned by the union. So the employer was not prosecuted, because what was practically, when you think about it, stopping the employer being 4 kilometres underground giving a safety briefing to the miners. They were not prosecuted. The organisation that prepared a particular map, that is an instrument of the New South Wales Government, the Department of Mines, and the map that the miners who were killed were relying on showed the location of old unused mine shafts that had filled with water 4 kilometres underground, as you can imagine, under intense pressure. The Department of Mines had not produced a reliable map. They could have, should have, nothing's preventing them from being reliable. The miners thought the abandoned coal mine, the mine shaft was either below them or above them. I'm not sure which, but no, not in front of them. But in fact it was in front of them. So they drilled into the mine shaft wall, into the old mine and into the water that was under intense pressure, which blasted out at great speed and pressure and killed them. And it jettisoned their bodies several hundred metres along the mine shaft, a grotesque accident. Well, the employer wasn't prosecuted, and the creator of the map wasn't prosecuted. Who was prosecuted was the owner of the mine, who committed the statutory offence of ownership, you might say. But worse than that, the 3 individual managers who were on duty that day 4 kilometres away. Those people, those individuals, those persons should have been down there doing what? Stopping them from working until they had gone back to the Department of Mines and looked at the map. Doing what? Well, those people were prosecuted. It was quite a damaging case, and it was one of the several things that led to persons being apprehensive about occupational health and safety in New South Wales. It's no longer the case that it's now before the district court. If you haven't done it, then you get off. If you have done it, then you don't get off, and that's what we should assume in all cases. Now, in that context, let me turn back to the Migration Act 1958. It says something the same thing. Section 474. Decisions under Act are final. Did I say vital? Decisions under Act are final. And a privative, that's the heading. It's called a privative clause decision. Much the same meaning, although different words, as we found in Section 175 of the State Act, which had a long-term negative repercussion for the New South Wales Industrial Relations Commission, which is not a good thing, because it had a history of which it could be proud over the 20th century, but it's now gone. It's been virtually abolished. A privative clause decision is final and conclusive and must not be challenged, appealed against, reviewed, quashed or called into question in any court, and is not subject to prohibition, mandamus, injunction, declaration or certiorari in any court on any account. Now, that's a privative clause decision. A privative clause decision is a decision of the AAT when it's ruling on things like a passport. It's a decision under the Migration Act. It's a decision of the department, which is a delegate, public servant employed by the department who makes a decision. It's the Migration Review Tribunal, where people are appealing against deportation, etc., or the Refugee Review Tribunal, where people are seeking to be recognised as a refugee. So if they make a decision, you can't appeal. Now, that is to be read in conjunction with a couple of things in the Act. It says, and that's section 5E, there's a word called a purported privative clause decision. This is section 5E. A purported privative clause decision means a decision purportedly made, proposed to be made, or required to be made under this Act, under a regulation or other instrument made under this Act, whether in purported exercise of a discretion or not. That would be a privative clause decision if there were not. Now, read that at your will, section 5E. It sounds a lot less gobbledygook if you read it than if you hear me say it. But it says, if the tribunal has failed to exercise jurisdiction or commits an excess of jurisdiction in the making of the decision, therefore it's not a privative clause decision. So what do we do about that? That we've got read in the context of what is to be done in the migration jurisdiction. How do we overcome a decision that cannot be appealed against? Well, we have to look at the duty of the tribunals. Section 424A says this: it must give to the applicant in a way that the tribunal considers appropriate in the circumstances. Now there's its discretion. Clear particulars of any information that the tribunal considers would be the reason or part of the reason for affirming that a decision that is under review. What that means, affirming a decision, means people obviously don't appeal if they win at the department. People only appeal if they're dissatisfied with the decision of the department. And the jurisdiction of the tribunal is either to overturn the decision and substitute it with one of its own, overturn the decision and to return it to the department for review with a recommendation that something take place, or overturn or affirm the decision, say no, that was a correct decision. So if they look like they're going to affirm the decision, they have to give clear reasons. Then they must invite the applicant to comment, and the information must be given to the applicant in writing or at a hearing, by a method prescribed for the purpose of giving documents. So that has to be either written or verbally. So it has to be clear. Now, if that doesn't happen clearly, then that's an excess of jurisdiction. So what does happen? If we look at Kirk and Dyson Hayden and the High Court, says that privative clauses only exist if the tribunal concerned is acting within its jurisdiction. Now, it's not within the jurisdiction to do certain things, and one of the things is to be biased. If you can't prove a person is biased, or you might be able to, but it'd have to be blatant and unusual. But a reasonable person could apprehend them to be biased, in which case a reasonable person could form the apprehension that they have acted outside their jurisdiction, and within the jurisdiction they have to listen. Section 420 of the Migration Act, they have to listen and they have to make a decision based on the facts and the law. Now, if that doesn't happen, what are the criteria? If you say, I, being a reasonable person, believe that an apprehension of bias exists, then we can look at a number of cases, and that is, the first one is RL&D Investments, which is the New South Wales Supreme Court of 2002. And it's about an error of law, an appeal on a question of law. So we're talking about not on a question of fact. You can't appeal on a question of fact. That's the Industrial Relations Commission, and that's the Migration Refugee Review Tribunal. You can only appeal on a question of law. Kirk won because he had been called as a witness. They breached their jurisdiction. They acted outside the law, outside the rules of evidence. In this case, if they act outside the obligation to listen and grant a reasonable and unbiased consideration, then that's acting outside their jurisdiction. But in this case of RL&D Investments versus Bisbee, the law was considered, said a finding of fact by a tribunal of fact cannot be disturbed if the facts inferred by the tribunal upon which the finding is based are capable of supporting its finding, and there is evidence capable of supporting its inferences. Now, it's important to remember that's if you're appealing against an ordinary court or an ordinary tribunal. If there's something bizarre and bloody-minded, then it is, so long as it can be shown, or it can't be shown otherwise, that the tribunal has conducted itself within its jurisdiction, that's listened, heard everything, done everything, but then made a decision on merits. We've got an example at the moment where the American State Department, the World Health Organization, the United Nations, the Australian Department of Foreign Affairs and Trade, and the International Red Cross all believe and rely on reports and statistics that 97% of women in Egypt, the variation is between 92 and 97%, depending on which report you read, they all unanimously, in any case, believe that 90% more plus, 90% plus of females in Egypt are subject to genital mutilation, either of their own free will or against their will. We brought an action on behalf of 3 young female children who we maintained would be subjected against their will because of the social order they were about to go back to in Egypt if they returned to suffer this mutilation. The person on the tribunal said that he had read an article or relied on a person who said no, that wasn't true and it's reducing, and if you look at statistics between the ages of 0 and 15, I think it was, it's a very, very small potential. Now, that's how to lie with statistics, because if you're aged between 0 and 15, then you've got a pretty good chance of being aged under 7 or under 12 or under 14. So, of course, there's fewer, but if you take all female persons, it's over 90%. And between the ages of 15 and death, it's over 90%. So this person really lied with statistics, but it suggested that the privative clause protected that nonsense. Well, that wouldn't be the case in a proper court. It would just get laughed at. We've seen there's a nasty case once written where this is where the New South Wales Court of Appeal said this is an appeal from His Honour Judge such and such of the District Court. There are also other grounds of appeal. Well, you couldn't do that in that case, as bizarre as the finding might be. But that person did commit several serious errors of law which are yet to be tested. Now, but even so, you can't just say I lost. You can't say I didn't like that hearing, that finding. It was wrong. It's not a simple thing to say that a finding should be overturned. Now, you can overturn something if there's no evidence to support the inference, or if the facts inferred by it and supported by evidence are incapable of justifying the findings of fact based upon those inferences, or it has misdirected itself in law. Now, of those 3, A, B and C, misdirected itself in law is probably all that's left if you've got a privative clause. If they've used a wrong inference, relied on a wrong authority, simply said something that is a reasonable person could not possibly have said, that doesn't matter. We're not talking about reasonable, we're talking about jurisdiction. So that overcoming the privative clause requires the finding that they've misdirected themselves in law. Now, it's not an error of law to simply make a wrong finding. We're still on that same case. Unless there is no evidence to support that finding. Now, you'd have to ask if there might be an apprehension of bias if there's absolutely no evidence. You could invite a court to find that if the person disregarded all the evidence but relied on something quite silly, then that's an indication that they haven't discharged the statutory obligation to listen, to consider, and to let things happen on their merits. It's not about merit finding, it's about not listening, not hearing, not giving a person an opportunity to present their case. It's not an error of law, though, if the finding of fact is perverse. Does not amount to error of law if the finding in fact of the inference is perverse in the sense that it is contrary to the overwhelming weight of evidence. That's not an error of law, that's an error of fact. That's probably the difficulty you've got with a privative clause. Something just completely insane and laughable and holding the tribunal up to ridicule is not enough to get around a privative clause. It has to be an error of law. It is not an error of law even if the reasoning process by which the court reached its conclusion is demonstrably unsound or illogical. That's an error of merit, an error of fact, not an error of law. So we have to go further than that. There is limited exception in relation to decisions of fact in which the context of a statutory description, in such a case there may be an error of law if the decision on the facts is one which could not be reasonably entertained or supported if the tribunal had properly understood the true construction of the relevant enactment. So what that means is that if the error disclosed a failure to listen, then it was an error of law. That is the burden of proof on you. It's not a burden, not something that's simply taken into account. Then there will be an error of law in this circumstance. The question whether there is any evidence of a particular fact is a question of law. Where there is any evidence of a particular fact is a question of law. Likewise, the question whether a particular inference can be drawn from facts found or agreed is a question of law. This is because before the inference is drawn, there is the preliminary question whether the evidence reasonably admits of different conclusions. So in the context of judicial review, it has been accepting that the making of findings and the drawing of influence in the absence of evidence is an error of law. So a court and a tribunal is not permitted to simply say stuff if there's no basis for it. You can't say, well, I think that, or I completely disregard all that, because it's an indication that they've not given proper hearing. Now, you have to ask, why would a person want to make a finding that is absolutely, completely contrary to the evidence? It might be that they're uninformed, it might be that they bring their own point of view to the matter, which they're allowed to, or it might be that they're biased. So what would a reasonable person need to establish that they're biased? That we're not proving the person's biased, we're establishing that a reasonable person would apprehend bias. Now, if so, then they have to listen. If they don't listen, if they're not letting a thing happen on the facts and the law, they're letting it happen on the basis of what appears to be to a reasonable person to be in their own bias, and that's apprehended bias, and that's a question of law which can be appealed against. And this is what it says, and the reference case is Embertec, EMBERTEC Proprietary Limited versus Energy Efficient Technologies Proprietary Limited. It's Federal Court of Australia, 2013 to 16 April 2013 is the date. Firstly, a judge should not sit to hear a case if in all the circumstances a fair-minded lay observer might reasonably apprehend that the judge not bring an impartial and unprejudiced mind to the resolution of the question which he or she is required to decide. So what would a fair-minded, reasonable person think about the conduct of His Honour, the tribunal member? And that reference there is Johnson versus Johnson. It's a 2000 case from the High Court of Australia, 201 CLR 488. Then the next reference in this case is the test for apprehension of bias involves a consideration of possibilities, not probabilities, although the possibilities must be real and not remote. In other words, you think he couldn't possibly have thought that. How could anyone possibly think that? It has to be, in the circumstances, the reasonable person would be drawn, albeit against their will and reluctantly and with great disappointment, to conclusion X. Now the next thing is the application of the test requires two things. First, it requires the identification of what it is said might lead the judge to decide a case other than on its legal and factual merits. So you can't just say, you can't dress this up with, I don't like what he came up with, I didn't win. And he didn't really take any notice of my brilliant submissions. That's not enough. It has to be objectively standing back from it. This is what His Honour or tribunal member did, and this is what a reasonable person other than my good self would think was leading the judge to decide a case other than on its legal and factual merits. There must be an articulation of the logical connection between that matter and the feared deviation from the course of deciding the case on its merits. Now we can't have a case where, for instance, where there's one case where a person appealed because the judge clashed with, in a way that perhaps some persons might have feared they might not have done, with the advocate proceeding. That's the case, the advocate in the proceedings below. And that's the case of Barakat, B-A-R-A-K-A-T, versus Goritsas, G-O-R-I-T-S-A-S, New South Wales Court of Appeal 36. Excuse the top of my head, by the way, I'm reading from these documents. Now, the New South Wales Court of Appeal looked at this at paragraph 13. Reliance was placed on language used by the judge in the course of exchanges with senior counsel for the applicants, which was said to reflect scepticism and later disdain for the applicant's case. Everyone's probably been in such a case. Those submissions, however, did not squarely engage with the critical issues. The fair-minded lay observer must be taken to have heard the whole of the exchanges between counsel and the bench on the relevant days with some understanding of what was appropriate conduct for both counsel and the court and what was not. The fair-minded lay observer must be taken to have heard the whole of the exchanges. It can't be you saw them having a fight. It has to be the entire context of the matter. And further on in that case, at paragraph 40, an apprehension of bias in the sense of apprehension of prejudgment does not mean an apprehension that the case will be determined adversely to the interests of the complaining party. Well, failing that, everyone would have grounds of appeal. Or no, not everyone, only the losers would have grounds of appeal. It means a reasonable apprehension that the trial judge has formed a fixed view to which it may be expected he or she will adhere regardless of the evidence or the submissions made by the complaining party. Now that is apprehension of bias. Whatever I say, whatever I do, I am going to lose. And that was brought up in a case called SZRUI versus the Minister of Immigration. I forget what the name is this week. Minister for Immigration and Border Protection, or Minister for Border Force or something. They keep on getting more and more Boys Own Annual, but I think it was the Minister for Immigration at that time. That's 2013, Federal Court of Australia, full court, 80, and it's the 25th of July 2013. And in that case, it found that apprehension of bias was a legal issue and not a merits issue. So the apprehension of bias amounts, obviously it does, to a denial of procedural fairness. That's one of the questions, that's one of the principles. It's a denial of procedural fairness. And the court's inquiry is therefore directed to the apparent fairness of the process of the decision making that is under review. So that's one, apprehended of bias is a denial of procedural fairness. Under the Act, you have to exercise procedural fairness, and it's very clearly set out as to what that means in the Act. Then such an apprehension must be firmly established. That applies also to decisions of the tribunal as well as those of judicial officers This was a review, by the way, of a refugee review tribunal matter, not a court. So the apprehension must be firmly established. In the case under question, the transcript clearly showed the person saying, surely you don't expect me to believe that, I don't believe that, I'm not going to believe that, etc. So in other words, the person had, according to the apprehension of the reasonable fair-minded observer, made up their minds. Robust testing of claims does not invite a finding of apprehended bias. Quite often a judicial officer will sit there and start quizzing the advocate as to what does this mean, what does that mean, what are you saying there? Well, they're allowed to do that in order to get a clear understanding for themselves so they can make a clear judgment. Now, it's not to say that that's an indication you're going to lose either. Clear, robust testing is an even-handed thing to do, so that's not enough. Probing questions may actually alert the party to matters that must be addressed. Yes, you could say, well, yes, Your Honour, well, yes, tribunal member, we'll address that now. And the entirety of the circumstances must be taken into account. Well, that's been mentioned elsewhere. Although it is obviously undesirable for decision makers in the course of the hearing to be sarcastic or to show personal indignation, the entirety of the circumstances must be considered. Now, mocking people and laughing at them is an indication of apprehended bias, but if that's the only problem, then that's probably not enough. It has to be something that's part of the context. And in a case I'm thinking of at the moment, it definitely was part of the context. And in the judgment that was delivered that we're talking about in that case, it was like written flippantly and offhandedly. Now, the whole of the transcript of proceedings must be reviewed rather than sentences taken in isolation. So it's not enough to say, like that Barakat case and that SZRUI case, it's not enough to say the fellow said something unfortunate we will wish he hadn't said. It has to be considerably more than that. Now, go back to what that reasonable fair-minded observer is, and this is back to Embertech. It says, the reasonable or fair-minded observer is not taken to have a knowledge of the law, nor should be attributed nor should there be attributed to him or her an awareness of the judicial process that ordinary experience suggests not to be the case. In other words, we're not talking about a legal insight here. What would be, in order to maintain the legitimacy and the coherence and the standing in the community's eye of the tribunal, what would that fair-minded person think that person was doing in conducting the case? So we have the logical connection has to be made, that what would that fair-minded person think? Then the reasonable hypothetical observer understands that a judge is professional, but not presumed to reject the possibility of prejudgment. So if the judge comes out and says, look, I know all of this, it has happened, I've seen it with new judges. They come out and say, yes, I've read the papers, I know what the case is, you don't have to say anything. Well, that's just wrong. The job of any tribunal, and it's set out very clearly in the Migration Act, and obviously implied in other statutes, that the matter must be heard and must be considered, not done. I've made up my mind, what have you got to say? The apprehension would never arise if you simply said, well, this judge must know what he's doing because it's not for me to interfere. It has a reasonable, fair-minded, intelligent observer, albeit untrained in the law, has a right to be apprehensive about bias. Now, if that reasonable person is apprehensive because of the whole context of the matter, not just the isolated outpouring, then so be it. Then the next one is, the lay observer is not informed by a detailed knowledge of the law, nor is he or she invested with undue knowledge and sophistication or highly specialised knowledge. And that's a reference to the Johnson & Johnson case. Nevertheless, the fictitious bystander is not wholly uninformed and uninstructed about the law in general or the issues to be decided. In other words, a reasonably educated, interested person with some knowledge of what's going on could think, hang on a minute, this bloke's not listening. This person has come in here and decided they're going to wipe us out and we've lost. Now, that's, when you think about all good law, it's obvious when it's written down, like all good ideas. I wish I'd thought of them. The hypothetical observer is assumed to know the issues to be decided and the circumstances in which they came to be decided. Now, exceptions to the rule, there are exceptions to the rule, include necessity, waiver and special circumstances. The prejudgment principle is one basis on which a reasonable apprehension of bias may be found to exist if a fair-minded person reasonably apprehends or suspects that the tribunal has prejudged the case. That observer cannot have confidence in the decision. In other words, it's what the general public, the community, the intelligent electors of the Commonwealth would have confidence in. The notion is based upon the fundamental principle that justice must be seen to be done as well as done. Now, if it's not seen to be done, then it's one of the indicators of bias in the apprehended judgment of a reasonable, fair-minded observer. The relevant test is whether a reasonable observer might conclude that the decision-maker might not bring to his or her task an impartial mind by reason of prejudgment, in the sense that the decision-maker might be so committed to a conclusion as to be incapable of persuasion to a different view. I'll read that again. Whether a reasonable observer might conclude that the decision-maker might not bring to his or her task an impartial mind by reason of prejudgment, in the sense that the decision-maker might be so committed to a conclusion as to be incapable of persuasion to a different view. Now that goes beyond sceptical questioning. That goes beyond surely, Mr. Such, you don't think this or don't think that. It goes beyond. If you look at the context of the matter, not just the occasional remark or outburst, the context of the matter is that this person made up his/her mind when they walked into the room. We're done here. Now, then a reasonable observer might conclude that the decision maker might not bring to his or her task an impartial mind by reason of a prejudgment in the sense that the decision maker might be so committed to a conclusion as to be incapable of persuasion to a different view. That's the summary of that case. There's one more, and that's Minister for Immigration versus Gia, that the member was so committed to a conclusion already formed as to be incapable of alteration or of being persuaded differently, whatever evidence or argument may be presented. And that's 2001 205 CLR 507. Now, I lost is never grounds for appeal. It has to be based, in this case, based on the law only. The law was not satisfied. You have to refer to the Act. You have to refer to the conduct of, in the case of the Industrial Relations Commission, that Kirk case, the conduct of the matter having regard to the Evidence Act. In this matter, having regard to the Migration Act itself, and what must be done, what the procedural fairness provisions of the Act provide for, and what the required gestures to the applicant are. It's not enough to say, and we've got one case where a tribunal member has made 50 judgments so far and has found in favour of applicants in 2 of them. And you compare the annual report of the tribunal, where the average is, so what's 2? It's 4%, 4% success for applicants. In the tribunal annual report in the same period, dealing like with like, the rate of success for applicants was 30%. Interesting. But that's been tested by the federal court, the full court of the federal court, where a particular judge of the Federal Circuit Court was found to have had the same statistic, 30% for the general bench, and this person 2%. Well, that was found not to be grounds for considering apprehended bias, because every case stands alone. You can't say we can assume this person's going to do X because of what they've done in other cases. Every case must stand alone. And so that's not an indication of apprehended bias. And that was taken to be, that's the law. And when you think about it, that must be the law. Each case stands alone. If not, there'd be a lot of tendency findings in cases that you'd basically be convicted because you were a bad person, not because you'd done a bad thing. So that was sound law, but it is a profound disappointment, shall we say, that a person can take on a position and use it to indulge himself, to not listen, to statistically, on the basis of likelihood, in a non-jurisprudential way, make a decision that is not a decision that anybody else would make. Then there was a case where a particular judicial officer was dismissing matters at mention, in the sense of going to sort this all out. It was not the job of a tribunal member to sort this all out, or a judge to sort this all out. It is the job of any judicial or quasi-judicial person to listen. I think the great Justice McHugh did say in one of his reminiscences that when he first became a judge, he put a little note on the bench where no one else but him could see it that said, "Shut up and listen." So it is the job of a judicial officer to listen, to decide things on their merits and decide things in accordance with the law. It is just not, it is statutorily the case, and something we all live with, that during the jurisdiction that is now much smaller than it used to be, of the Industrial Relations Commission of New South Wales, that you could not appeal cases even though they were wrong. Husband and Walker had jurisdiction to be wrong. In the case of migration matters, you can't appeal them even if a reasonable person, being me, would not possibly have found that on the evidence. You have to show that the entire conduct of the matter has been so of such a nature that a reasonable person would not be confident that there was going to be a judgment. And that's apprehension of bias. It's not bias, it's what a reasonable person would apprehend to be bias. And that's a breach of law. You can't appeal on merit, you can't appeal on facts, you can only appeal on law. If they get the law wrong, privative clauses do not work. And apprehension of bias is an important way to consider all of that. Now, I hope that has been useful. My name's Chris McCardle, and thank you very much for watching.